You're listening to the Valley Current.
Hey, Steve, how you doing?
Yes, isn't technology great?
Well, it's amazing. You know, I remember reading these Gibson books about jacking in, and the guy who wrote Neuromancer and a bunch of other great books that predicted the future. And we all thought it was crazy, but more and more it's becoming pretty clear that you can reach anyone on video, with audio, with a sense of presence anywhere in the world where there's an internet connection, which is the entire world, given that Starlink has satellites that are running 7x24 by 365 if you buy their receiver, which most people are doing in remote areas. They're putting them on their vehicles. They're putting them in the middle of the desert. They're all over Mexico. They're happening all over the place. So it's an interconnected world, and it's becoming more and more so as we speak, right?
It is. I've actually read a few pieces by Gibson. It is.
The topic is, to what degree are we going to see this movement due to ChatGPT and artificial intelligence, whereby big accounting firms start to move into other swim lanes more generally? Obviously, there's lots of swim lanes they can move into legally, and they are moving into the law swim lane overseas, as we know, because announcements are being made that they're hiring more and more lawyers, and they actually have law firms under the CPA brand overseas, but not yet in the US. And you were explaining to me, which is why I thought it would be good to talk about it, that there's been a rule in force for quite a while that CPAs stay out of the law business in the US and lawyers stay out of the CPA business swim lane in the US. And I wonder if that's going to continue, given the way in which the international branches are moving to compete directly with BigLaw.
So, yes, I think that there's actually more teeth in the law side of it than the accounting side of it. I've been looking for teeth in those regulations, and I see teeth in two pieces. Number one is the rule that says that accountants should not market themselves deceptively.
Mm-hmm.
And then piece number two is the rules for attorneys that prevent attorneys from sharing fees with people who don't have a law license.
Right. But if you're a CPA and you have a law degree, you can practice law while you're a CPA and combine both skills, right? People do that all the time, right?
As long as your marketing is not deceptive.
Right. So you say, I practice law. Like I'll give you a good example that came up, and you can comment about this. So, when you do an asset purchase agreement, and we had one of our clients decide recently that they were going to sell their business, and the structure of the transaction was done as an asset sale. I won't reveal any of the details, but conceptually, it's a lengthy document. There's a lot of cycles. There's a lot of schedules. A lot of it has accounting functions to it, like allocation of consideration as against the different asset classes, various spreadsheets that get constructed with financial statements and receivables and payables and so on. And I was thinking to myself, it's a good example of where the way in which overseas firms, accounting firms, are moving into the legal field. They would say, oh, we can do that deal with combined lawyers and accountants and AI way, way faster than any of the big law people can do it. And of course, we've talked about on the podcast, some of these big law firms are charging huge amounts per hour and putting lots of timekeepers on a project. I mean, we don't do that. You don't do that. We're a small firm. You're a small firm. But at big law firms, and we've recently done a podcast about what Wachtell Rosen did as against Twitter, and Musk is now suing them, where they had like a huge number of people billing on that transaction and on that litigation, and then the settlement agreement as well. So the bill was huge. I think it turned out to be like over $100,000 an hour for each lawyer billable hour, or some humongous number that added to $90 million for 5 months worth of quote unquote work. Yeah, exactly. You're saying, oh my God, that was what was quoted in the pleading that was filed by Musk's acquisition company. One of the directors reacted to the bill saying, oh my God, like I never knew that we were authorizing that kind of volume of legal work, but it wasn't really just legal work. It was a multiplier for success, like a success multiplier. Now, I think accountants would never do that. Like you could argue that's a big difference, right? Accountants bill by the hour. They're pretty rigorous about keeping time records and the like. But I don't think you guys ever charge a success fee, do you?
I do not. However, the big four are an extremely powerful cartel, especially in their overseas practices. They can do things that I can't do or I would not do.
Well, is there an ethical rule? We have an ethical rule about the fees need to be reasonable, but then reasonable is defined with relation to the contract. And the contract can have a success fee, but usually it's tied to a discount or a contingency or a delayed payment or risk or something else. This was one that left it in the discretion of Wachtell Rosen to decide what they thought was a reasonable success fee. And they just said, well, it's going to be some multiple on what we bill. So if we bill 12 million, it's going to be like, maybe up to 5 or more times that. It turned out to be like 7 or 8 times that. Well, it's a huge number. And there is litigation now that's going on in the state courts in San Francisco, which is interesting. That's where they chose to file. But the reason I raise this is it seems like a lot of what's in that case is, hey, investment bankers get to charge success fees. So we as a big New York firm, Wachtell Rosen, we should get paid similarly to the bankers because we're just as important. We're on the playing field. We're in a quarterback role as well. We're just as important as the bankers. And that's a lot of the sort of the driver that's in the various emails that have been disclosed that were otherwise confidential. But Musk has waived the attorney-client privilege, saying, look at what happened here, really to embarrass Wachtell Rosen. I mean, they can afford to pay it. They had over $1 billion of revenue last year, and they're probably on track to do even more than that this year. And they're only like 80 partners, 80. It's a small firm, maybe a total of 200 associates. So it's under 300 lawyers. It's not a really big firm by dint of BigLaw, but they're one of the best, in fact, the most profitable firm. But, if you look at what's happening with CPAs, they see stuff like that, particularly the overseas ones in the big CPA firms, and they must say to themselves, there's a huge opportunity for us. We can compete against these guys, right?
Well, again, the sort of monopoly on multinational audit and the rules about related parties and independence give the Big Four cartel a huge power to write their own rules. They have tremendous influence over the profession and over the rule makers in the accounting standards bodies. So I would not put too much past them. I'll mention 2 other nits, one of which is that the IRS rules prevent contingent fees. They allow them in certain very limited situations, but essentially they prevent the charging of contingent fees. Also, the rules concerning attorney-client privilege affect this. If the accounting firm is actually preparing tax filings, even perhaps regulatory filings, then that potentially breaks the attorney-client privilege. And so a firm has to kind of decide whether they're delivering law services covered by attorney-client privilege or accounting services that usually by dint of the filing are not attorney-client protected.
What happens when they're doing both? So let's pretend they were working on this asset purchase agreement today, and they had someone that wore the hat of CPA, but also wore the hat of licensed attorney. License is in effect in both CPA license as well as attorney license, law license. And they're giving legal advice, and they're also giving accounting advice. They're probably giving some tax advice, and they're giving allocation advice. And, they're full service. And that would be a differentiator, right? Because they would say to the CEO who's selling these assets, why use two firms when you can use just me or my firm?
A misleading advertising potential there if the client is expecting legal services protected under attorney-client privilege and they're getting something else.
Oh, so you're saying there would have to be a full disclosure document of some sort that says the client understands have multiple roles. There could be some waiver of some privileged communication as a result.
Yes, to my limited understanding as a non-attorney, you need to be very careful to call it consulting.
Let's pretend that this mythical lawyer or firm also did the audit work for this seller as a corporation. Delaware Corporation ran the business for 5 or so years, and they did the audit work for the full 5 years. Would that be a conflict for them to negotiate this asset sale agreement, given that they did the audit work and the audit report? They're not selling stock. They're just selling assets.
Absolutely.
All the assets.
It would be a non-attest service. And under the USA and most exchanges that I'm familiar with, it would be prohibited.
Now the company is a private company that's selling the assets, but they're selling it to a public company. And the public company has their own in-house lawyers and in-house accountants. They're big enough to do this whole thing in-house, and they can, and they did.
At a very minimum, I think there would need to be board approval of the provision of non-attest services to an attest client, and there is a potential conflict there.
Okay.
And yes, the details are potentially problematic in the USA. Whereas
you see that there's interesting aspects, because if the seller private corporation's CEO has a lot of trust in this individual or this firm, they have a competitive advantage in getting the legal work, right? Because there's a trusted relationship that's probably almost daily dealing with accounting issues, right? So that's where, in some ways, the big CPA firms, particularly overseas, that are not, barred by these rules that are applicable in the U.S., can say in a marketing effort, hey, we're a lot more efficient than these big law firms, and we're using a lot more AI, and we're making it a centerpiece for our efficiency and our effectiveness. And if that works, if they actually get that pitch to work and they deliver on the pitch, two unknowns, but if they put enough resources in it, perhaps it'll all work out. It's a real competitive advantage, right?
Yes, indeed.
Because they would say something like, we've done so many of these asset purchase and sale agreements. We've got this large language model that has every version of every asset purchase agreement that was ever done on earth categorized into good ones versus bad ones, ones that avoid litigation into ones that have been thrown into litigation. And we're just going to suck your document into our LLM, our large language model, and we're going to see how it fares as against the other ones we've done, with some sort of automated report that compares and contrasts what's good, what's bad, what's ugly. And, that might take a big law firm, a senior partner and one associate and one paralegal, or maybe several. And that is going to be a big cost differentiator if this AI tool, let's call it, ChatGPT.law, ChatGPT.accounting, whatever we want to call it, that they're using, is actually expediting this process and providing a reliable report on.
It's far more.
Huh?
It's far more than just having the tools, but also having the relationships with the regulators.
Right. The tools, the talent, the technology, the regulation, the trusted relationship, the regulation with the regulators, if there's a SEC approval that's needed, or other things like that. But in many ways, I could see how, if the international side of the house says to the rest of the house, I'm talking big CPA firms now, the big four, as you say, that have more or less an oligopoly going on, where they control probably 80 or 90% of the Fortune 500, if not even more than that.
In fact, there's one of the big four single-handedly who does audit work for 75% of the Fortune 500.
And is that Deloitte, or who is that?
That's PW.
Okay, so Price Waterhouse. Okay, so Price Waterhouse Coopers, right? PwC.
Yes.
So conceptually, you could see how they would say, "Hey, we got to get some changes to happen in the U.S. because we're becoming hugely profitable with our approach, because these tools can easily translate over to the U.S. In fact, they're going to be built from a global point of view, probably from the get-go. And once they have them and they prove that they work and they save time and money and they create more profit, it seems inevitable that there's going to be a push to sort of get the domestic side, the U.S. side, to say, you guys have to do something to get some changes to happen, because we should be competing using these tools in the way we're succeeding overseas. And to me, that would seem to be a real risk for particularly big transactional law firms. I don't know that CPAs want to get in the litigation game, but that would be the next step afterwards, that they actually get into the litigation game as more than just the consultants that they are now, where they often provide expert witnesses and other forensic consulting and the like, right? Where they're actually doing the advocacy, they're actually doing the trial work, they're actually writing the briefs.
From the perspective of running a tiny firm, we have our hands full with just the tax.
Oh, yeah. No, I mean, obviously, this only works if you realize these firms are so big. I saw some data that I think you sent me that says it's a huge number of people worldwide that work for these four big CPA firms. And the total revenue is in the, I don't know, hundreds of billions, I thought is what I read, like a huge number, right?
Yes. And it was perhaps one or two people in 10,000 who work for one of these firms.
Right. So globally, it's a huge number of people that are doing more than just accounting, because they're doing a lot of consulting. That was 50% of those numbers. And they're doing, to some degree overseas, a lot of legal work, which is allowed. So it seems to me inevitable that those people will continue to start to compete more effectively against big law firms, and big law firms have to sort of start weaponizing these AI systems too, just to compete against the accountants. And similarly, once they do that, these are mostly global firms, global law firms, they're going to be saying to some degree, we need to be able to maybe bring some accountants in and start competing on accounting, because we want to be full service the way these guys overseas are saying they're full service, right?
That's certainly possible. And again, I think it's more than the tools. I think the relationship with the regulators is a huge piece of it. In UK, recent talk about breaking up the big four. I'm not sure how successful that has been. Here in the US, PCAOB, which regulates the accounting side of it, has been finding large numbers of defective audits. There, again, there's the possibility of regulatory enforcement to reduce the power of the big four cartels.
What is that acronym that you gave us? What
regulatory body is called the PCAOB, the Public Company Accounting Oversight Board, affectionately known for the pronunciation of their acronym as Peekaboo, PCAOB.
Is that a worldwide organization?
That's the U.S. oversight of the audit function.
Is that an actual governmental entity, or is it an NGO that's sort of an association, or what is it?
It's not an actual government body, but it's written into the code. It's written into the SEC rules.
Okay. I mean, what inspired us to do this discussion is that I sent you something I saw that I flagged that said KPMG put somebody in charge of its AI initiative, a 50-odd-year-old guy who has, I guess, worked for the firm for quite a lengthy period of time. And they interviewed him, and he talked about there's nearly 4,000 lawyers over some 85 jurisdictions in, overseas, Europe, Middle East, Asia Pacific, and so on, that are engaged in the practice of law. I think he is in Australia. His name is Stuart Fuller, basically saying, yeah, we're going to make a big push to use AI. And that led me to wonder, well, what does that actually mean in terms of legal work that's combined with accounting work? Because it seems to me the other interesting thing would be that they would be training a particular version of their LLM in a relatively unique way, right? Because it would include the accounting rules. It would include probably some tax regulatory aspects. It would include more than just law, because their focus is much wider in delivering what I would call as the combined services, right?
Indeed. And I actually have personal experience going up against KPMG, and their knowledge and their performance in that situation was impressive.
It was impressive, right?
Yes, it was.
So, that competency presumably is going to grow, and some of that competency gets embedded into the AI. I mean, that becomes the game that gets played, right? Over time.
Absolutely.
And you could argue that, well, there'll be tools that smaller practitioners and smaller firms can use, but they won't be as necessarily as comprehensive. And obviously the Westlaws of the world and the Lexuses of the world and Case Text, which is just acquired by Westlaw, they will start to build some of this into systems that are available to all lawyers and all accountants and all lawyers who are accountants and vice versa. But will they actually end up being able to be as comprehensive based upon the number of people that are doing the number of deals that these big four accounting firms, the big four, if I remember, is PwC, EY, Deloitte, and KPMG, right? Those are the big four.
Correct. Just looking at going to the tools side of things, there are a handful of audit tools out there that allow one to research the US GAAP and the IFSR, the International Financial Standards. And four of the five major tools for researching audit and financial rules come from the big four firms. And for a small firm to have the multinational perspective, just think of US cross multi-state litigation and then multiply that by 100 to reach, or maybe 200 to reach the scope of all the possible international combinations that can happen. For a small firm to master the practice in both USA and Tasmania or wherever, it's impossible. So the big four will dominate. Small firm almost gives up in advance because you can't possibly acquire the combination of merger experience that is needed to practice internationally.
And your point, I think, is well taken, that once this oligopoly is in place and it locks up the various systems, as they were, or competencies, in a way that becomes almost impossible for a new entrant to come in. Because I remember back in the day, it was the big eight. There were 8 such accounting firms that kind of controlled the world of accounting. and then it became the big six. It was always seemed to be an even number. It was never kind of an odd number for some reason. I don't know what that was, but eventually it shrunk down to just four. And your point is, well, maybe at some point the government, whether it's the UK government, the US government, or some EU group, says, look, we need to have more firms competing. We can't have the amount of monopolization that this group of firms has. And you could say the same thing arguably is true with respect to big tech to some degree. Big tech keeps getting bigger, and there's like 6 big players at this point that seem to dominate over and over again in the delivery of communication services and various tools and communities and the like, whether you call it Google.
There's really conflicting objectives from the regulators. On the one hand, they want competition, a competitive market. And on the other hand, they want to shut down firms that are not big enough to have the competency to get the multinational audits right. And looking at PCAOB grading of audits that they review, small firms having 50% or more of their audits defective, whereas the big four down to acceptable levels of 10 to 30% of their audits being defective.
Right. Do you think the audit process itself will become more automated at some level, or is that just impossible to imagine because there's just too many judgment calls that have to be made at too many layers to do an audit properly?
Much of this is really the same problem that's happening in tax, that there's no incentive to make things simple. The incentives are all to make things more complicated. So what's the safe harbor? 20 years ago, you'd get public company financial statements that were 20 pages long,
right?
And now they're 200 pages long, and nobody is willing to bet their career on removing a paragraph that was used the previous year.
Right.
If it was needed the previous year, the safest thing to do is repeat it this year and add another paragraph or two, because every time there's a problem, when there's an Enron, they make a whole bunch of new rules to prevent future Enrons. And so there's no incentive for anybody to simplify or get rid of rules or to get rid of paragraphs in these public company financials. I look at, as a professional who works on these documents, I can't read, I can't understand half the stuff that's in them. And when I think of a retired person who on their own without professional help might be trying to make investment decisions, it boggles the imagination that a retired person who doesn't have a CPA and a law degree would be able to read these documents and make sense of them.
Right. And the documents, you have to assume the document is not cooked, that it's actually a full disclosure document and it hasn't been subject to some fraudulent insertions of representations or statements that are untrue. And of course, we find out later, often much later, like in the Enron case and also in the blood company case, the Theranos case. Why I couldn't remember. She's in jail.
I had a conversation with my 12-year-old son last night about the submarine Ocean Gate that just sunk. And I asked him, well, was it fraud? And did somebody commit a felony there? And so we went over the 7 elements of fraud that are commonly accepted by courts.
Right.
Intentional material misstatement, rightful reliance, and consequential damages.
Right.
We went through each of them. Intent is always subjective and very hard to prove. But in this case, rightful is really the showstopper, in my opinion, because the disclaimer that the tourists signed listed death a whole bunch of times. So experimental could result in death. And public company financials are the same. They are all about covering your backside. And there, again, the motivation is to say, you can lose your money. You could lose your money. Yes, you could lose your money.
Right. So just to like focus us for a second on this example I give, because I'm kind of curious how you would look at this. Let's look at this tax allocation thing. I'm not a tax expert. You are. I'm not an accountant. You are. I negotiate and draft this agreement and finalize the deal. And then there's a schedule that has a proposed allocation of consideration across, let's call it a dozen different categories, and how those allocation numbers are embedded into that schedule will impact, perhaps even in a material way, what the net outcome is for the seller after tax versus what the net outcome is for the buyer after tax. So even though it's often left to the end, it can have sort of deal-breaking consequences that you would want to know almost before you start negotiating the deal. Look, are we going to have a showstopper here because you want to allocate 100% of the consideration to this set of depreciable assets, and we want to allocate closer to 100% to something else? You know what I'm saying?
Absolutely.
You'd want to know that. You deal with this all the time. But I have to tell you, the lawyers never think, well, let's start, we should find out from input from the accountants how we're going to handle these allocation issues, because if we get to the end after all these cycles and drafting and this indemnification and that warranty and this limitation of liability, this governing law, this arbitration clause, all this other stuff, if there's a deal breaker on the tax economics, what I'm calling the tax economics, we might as well know that up front, because if we can't compromise that, then what's the point of even negotiating all this other boilerplate, right?
Well, you can do the deal without the 1060 code section allocation, but it's not recommended. So if you do that allocation, then the IRS policy is to accept this allocation that both parties have signed on the assumption that, well, somebody is going to pay the tax. At least the IRS will not be whipsawed, where one party says, oh, no, it's all the other party, and the other party says, oh, no, it's all the former party. But this mutually agreed upon allocation says, oh, no, we know exactly who's responsible for what. And then that significantly reduces audit risk. So it's a cherry on the sundae, and you do want that cherry.
Right. And your point, I think indirectly, is, look, if you guys end up signing a contract that doesn't have anything in the schedule, well, you've got a deal, but the tax allocation is like, who's going to get audited first? That may impact this, right? So,
and the underlying conclusion there is bring tax into a business combination early. In fact, when you start your startup, you very well might want a tax person involved and an IP attorney. You want both,
right,
legal and the tax. For example, the founder is often best served by holding their IP personally,
right,
not in the corporation. But often by the time me or somebody else with a tax background gets to the situation, the IP has already been titled to the corporation, and
right,
then it's all really owned by the investors, and it's too late for the founder to get their cherry.
I just had this exact conversation with a founder, and literally his eyes lit up. Actually, two founders, her eyes lit up, and then his eyes lit up. Like, well, we had no idea that we could form our own separate LLC and license the technology into the operating company and firewall it against lawsuits and the like. And they were like, the big law firm that we consulted with didn't even tell us that was a possibility. Of course, those big law firms are typically somewhat biased towards the venture capital community, and they want to make sure the venture capital community bear hugs everything that can be bear hugged. But the truth is, if the founders are not going to get venture capital, or are going to delay it, or are going to rely on family and friends' money, probably makes a lot of sense to firewall that intellectual property, because if there's an early failure, you don't want a bunch of creditors to end up getting control, which of course they won't do anything with. It'll just be destroyed it'll be locked up in various claims and no one will be able to take advantage of it. So I agree with you 100%. But of course, founders, they don't know this sort of area very well, and they haven't lived through all the experiences that you and I have seen. So they don't think to themselves, yes, we should do that. And, that becomes just an endless discussion with respect to what's possible.
Absolutely. So much more there. The KPMG situation, I mentioned the founder went and successfully exited with huge gains, and then took the same invention and started a new company in a slightly different arena.
Right.
And the only reason he could do that is because his license limited the application to the specific industry. And
Right.
so when, after completing his first success, he can go on and do the same thing in another marketplace, and
Right.
with this, without having the heavy lifting of having a whole new invention, because he can recycle that IP in multiple separate industries repeatedly as often as he wants, and create.
Right. That's something that people don't realize. A lot of inventions, like take Tesla, the invention is probably more about the battery technology than it is about the car. I mean, the car is important and its quality is important and the electronics are important, but the battery and the battery system may propel trucks, which they're getting into. It will propel trucks. Maybe will propel planes someday, helicopters. There are people that are talking about maybe motorboats will eventually move towards electric as opposed to fossil fuel. And so really anything and everything that has some sort of drivetrain could be battery powered in the future, particularly if you imagine a world where energy is plentiful from sun, solar, or other sources. People are talking about, I saw a documentary last night that's talking about maybe fusion is a reality. We thought cold fusion was a hoax, but maybe there's a form of hot fusion that is a reality that's going to produce low cost energy that's pollution free. I'll send you the link to the documentary. I'll send you the link to that podcast too after we're done. But let's give the audience your details, because you're the go-to person, and I may send a client your way for this tax allocation stuff that we talked about, because he needs some help figuring out how to decide what to do with these assets the deal's not signed yet and the schedule is not finalized, but there may be a bit of work there. So I wanted to reach out to you today because you're the guy, you're the man. So tell people how to reach you, Steve.
Thank you kindly. My cell phone is 408-887-6433. My website is www.taxservice2u, that's a number 2, the letter U.com. Those are the two most popular ways to reach me.
And
so,
you always pick up the phone, Steve, and you're always there by email as well, which is what? Rabin, SRABIN @srabin.com, right? You get your name.
Absolutely. Thank you for your kind words and for hosting this podcast.
Yeah.
It's been a pleasure to be here.
Great. Thanks, Steve. Talk to you later. Take care.
Indeed.
Have a good weekend. Bye-bye.
Tune in next time on The Valley Current.